Welcome back to the Supreme Court of the United Kingdom, where we are continuing to hear the appeal in the case of Manchester Building Society and Grant Thornton. We're hearing the submissions just now on behalf of Grant Thornton, and I'll invite their counsel, Mr. Salcedo, Queen's Counsel, to resume his submission.
Thank you, my lord. My lords, my lady, I was on page 1000 of the bundle in the judgment in the case of Anaco, and I was looking at the minority judgment of Lord Millet, and I just looked at paragraph 54, and I'd now invite your attention to the next page 1001, where at paragraph 58, Lord Millet also makes clear that the scope of duty principle is not about causation. Just after the inset quote in paragraph 58, Lord Millet says, for the moment, it's sufficient to say that it's necessary to separate the issue of causation, which is a question of fact, and the issue of legal responsibility, which is a question of law. At page 1002 in the bundle, paragraph 62 of the judgment, Lord Millet makes a point about information and advice, which is relevant to a submission that I think my learned friend faintly made as one of her sort of fourth alternatives, that if it was if it had to be analysed as information and advice, then this was an advice case on the basis that the relevant transaction was hedge accounting, which is a submission that's been made before. Lord Millet, in paragraph 62, makes the point that so I'm looking at on the left-hand column in the middle of the paragraph. Even where the defendant assumes responsibility for advising generally whether or not a course of action shall be taken, it's still necessary to identify the particular course of action in question. Where the question is whether to enter into a particular transaction, it is necessary to identify the relevant transaction, for the defendant is not responsible for loss arising from any other transaction. And of course, that could be said, that goes right back to Lord Justice Denning in Candler and Crane Christmas, the very transaction. And at the top of the right-hand column at the end of that paragraph, it is never enough to say the defendant was responsible for advising the plaintiff what action he should take. It is necessary to ask in relation to what. His liability is limited to losses arising from the particular transaction in relation to which the advice was given. Where the defendant gave professional advice, his profession will usually supply the answer. So here, the argument that hedge accounting was the relevant course of action or transaction is completely wrong. The transaction that causes the loss is the buying of the swaps. That's the direct cause of the claimed loss. Grant Thornton did not advise on that transaction. If you can call it a transaction, the transaction on which Grant Thornton advised was simply how the transaction should be accounted for, which is not in ordinary parlance a transaction at all. But that was what the advice was about. My lords, going on in the same page to 63 to 64, Lord Millet describes the NICredit case in terms that are helpful to analysing the present case, especially the last few lines of paragraph 64. In other words, the valuers have been asked to advise on the value of the security and not on the viability of the project. As always, in Lord Ruskill's words in Caparo, it is necessary to determine for what purposes and in what circumstances the information in question is to be given. And that's absolutely right and applicable. Grant Thornton was not asked to advise on the viability of the project. On page 1003 of the bundle, page 191 of this report, paragraph 66, Lord Millet summarises the law on scope of duty in terms that were later adopted by this court in Hughes Holland. And notice in particular, if you would, point 4, where Lord Millet repeats that it's necessary to identify the transaction in question. And then at the end of that paragraph, a broker should not likely be assumed to undertake responsibility for an underwriting decision. And obviously that was the relevant point in Anaco. But here we say an advisor about an accounting treatment should not likely be assumed to undertake responsibility for a commercial decision that will then be accounted for. And Lord Millet then examines the facts in detail, and dissenting held that they did not disclose a duty on the part of the brokers to advise Anaco what course of action to take. My lords, the next case is that the last one of these big cases is Hughes Holland, which is in our bundle at 1247. And in this case, in this court, the claimant argued that Samco had introduced a number of novel and unwarranted propositions into the law. We can see that if we need to at 1252, page 604C of the report. And 4 unwarranted propositions were identified in the claimant's argument: the existence of the counterfactual question, the advice information distinction, the abolition of no transaction unless a transaction distinction, and the principle that the negligent provider of information should be liable only for the consequences of it being wrong. The claimant argued on the next page, at 605D in the report, that Samco should be seen as a policy decision about lenders and valuers, and that the result should have been reached by applying the contractual remoteness test and finding that as a matter of construction of the retainer, the valuer only assumed responsibility for loss suffered to the extent of the overvaluation. That was what was argued by the claimant, and as your lordships know, that was none of that was accepted. If we go to the start of the judgment at 1257, again, as your lordships know, there's one judgment given by Lord Sumption, with whom the rest of the court agreed. And the issue is framed, characteristically for Lord Sumption, if I may say so, in the first sentence of the judgment. The issue on this appeal is, in summary, what damages are recoverable in a case where, 1, but for the negligence of a professional advisor, his client would not have embarked on some course of action, but 2, part or all of the loss which he suffered by doing so arose from risks which it was no part of the advisor's duty to protect his client against. Now, my lords, my lady, that is the issue which engages the Samco principle, the scope of duty principle. I was asked before lunch, do I accept there's any exceptions? And I said, no, I don't accept there's any exceptions. And I think I said this at the time. If we are in a situation of that sort, that is what engages the principle. It's that situation that creates, if you like, a new problem where the traditional approach to causation would say that the advisor's negligence was a cause of the transaction, and therefore, on a traditional approach to causation, it is the cause of everything that follows from the transaction. But nevertheless, it's obviously unfair for the advisor to be saddled with all the negative consequences of the transaction when the advisor may have contributed only one part, which may be, as in the current case, a very small part of the considerations that led the claimant to enter into that transaction or follow that course of action. In the event, the appeal in Hughes Holland was decided on the facts. The key question turned out to be whether the development, as Mr. Gabriel had understood it to be, would have been financially viable. The judge said it would. The Court of Appeal allowed the appeal on the grounds that the judge had reversed the burden of proof. The Supreme Court dismissed the appeal, ultimately, on the basis that the evidence established that the project was not viable. And we see that at paragraphs 12 and 14. 12 is on page 1260 of our bundle, where the judge is quoted. And then at 14, the Court of Appeal is quoted as saying that there was no positive evidence to the effect that the value would have ensured recovery of the loan, in other words, that the transaction was viable. And then Lord Sumption's analysis at paragraph 18 on the facts, ending at page 1263 of the bundle, letter E. What stands out is that even on that hypothesis, the judge made no finding that it would have enabled Mr. Gabriel to recover his investment, only that the possibility could not be ruled out. In the face of the evidence which I've summarised, this falls a long way short of a finding that the project was viable at any stage. And so in his judgment, irrespective of the incidence of the burden of proof, the Court of Appeal was entitled to find that the expenditure would not have enhanced the value, and therefore the factual basis of the defendant's case on damages was sound. And then at paragraph 20, Lord Sumption points out that there are several filters that limit the matters for which a wrongdoer is legally responsible, one of which is legal causation, but that the filters, and we're now on page 1264 at letter C, the filters are not limited to those that can be analysed in terms of causation. But ultimately, they depend on a developed judicial instinct about the nature or extent of the duty which the wrongdoer as broken. For the underlying principle, at 1266, paragraph 25, Lord Sumption quotes Mr. Justice Phillips from first instance in Bank Bruxelles became Samco, that he doesn't see why a negligent advice in respect of one head of risk should make the advisor the underwriter of the entire venture, more particularly when the negligent advice relates to the existence or amount of some security against risk in the venture. I don't see why the advisor should be liable for all the consequences of the venture, whether or not security in question would have protected against them. So that he then says at 27 that the House of Lords in Samco accepted the principle underlying Mr. Justice Phillips' decision, but their reasoning was more elaborate and the way they applied it was different. And he says the essential distinction which underlies the whole of Lord Hoffman's analysis is between the assessment of the loss caused by the breach of duty and the extent of the defendant's duty to protect the claimant against it. So the essential distinction there is between the loss caused and the scope of duty to protect against that loss. And then going on to paragraph 30 on page...
Well, the very next sentence, he addresses the point that was raised before lunch.
Yes.
Yeah.
Yes, and yes, that's right. Lord Hoffman said that was the wrong place to begin. But I think my answer remains the one I gave, that I'm not submitting that it makes any difference where you begin. What I'm submitting is you do have to recognise that both of these are relevant filters that must be considered where you're in a scope of duty situation. And they both apply. And it can't make any difference which one you start with. And then I was going to go to 1267, paragraph 30. Lord Sumption sets out the way that Lord Hoffman assessed the damages with the principle that the loss should not exceed that which could have been claimed if the valuer had warranted the accuracy of the information. At 1268, paragraph 31, Lord Sumption says the principle is essentially a negative one. The lender's prima facie, on this basis, entitled to the loss flowing from his entry into the transaction, except for those that would still have been suffered if the property had been worth what the valuer said it was worth. And then at 32, he makes the point that Lord Hoffman rejected the cap label because the two stages of assessment are directed to two different things. And that's an echo of the point that I drew attention to from Lord Millett in Platform Homes. The two stages assess two different things. And then at 1269, paragraph 33, just above letter C, Lord Sumption adopts Lord Hobhouse's statement from Platform Homes that in the result, the damages are confined to that part of the claimant's basic loss caused by the negligence that can be equated in money terms to the amount of the evaluation. And that again is recognising that we're actually looking at two different things. It's not, strictly speaking, a cap on one thing. It's looking at the amount in money terms, which is the extent of the duty, the amount of risk that the defendant is properly assessed as having been taken by giving the advice, and that is the cap which is applied to the basic loss, which may be a different amount. And then still on that page, Lord Sumption refers to two fundamental features of the reasoning in Samco. That's paragraph 34. And the first fundamental feature is that the defendant has no legal responsibility for the claimant's decision. And that is a really fundamental feature here. It's why in some ways this situation is the situation that engages scope of duty is different from a situation of an ordinary bilateral contract where two parties take on rights and obligations to each other on approximately equal terms, or so the law will presume until proved otherwise. It's different from that. In this situation, it's the claimant's course of action, and the defendant is providing one element, which may be a very important element, like a valuation in a lending decision, or it may be really quite a marginal element, but nevertheless a necessary one, such as hedge accounting to a decision to start on a whole course of buying mortgages and swaps. And then the second fundamental principle at 36 is that the principle has nothing to do with causation of loss as that expression is usually understood in the law. And my submission is that that's letter G, what Lord Sumption means by that is that, of course, one can relabel the whole thing as causation, but that's a relabeling. But causation as it's normally understood runs in a chain from the negligence to the transaction to the losses from the transaction. And if that's how you understand causation, then scope of duty is addressing a different question. Lord Burrows.
Isn't it fair to say, as was put by your opponent, that what Lord Sumption is clearly there referring to is what the law is referring to as factual causation and not legal causation? He's talking about the historical connection that would be established, for example, by a but-for test.
No, my lord, that would not be fair, and you can see that from the fact that this is supported then by a quote from Lord Hoffman from NICredit number 2, which includes the 4 lines down. It was accepted that the whole loss suffered by reason of the fall of the property market was, as a matter of causation, properly attributable to the lender having entered into the transaction. Now, that's a reference to legal causation, not just factual causation.
That's perhaps more apparent from the next sentence.
Yeah. Yes, well, it may well be. It's not suggested the possibility of a fall was unforeseeable, or there was any other factor that negated the causal connection. And indeed, nor if one started from the proposition the valuer is responsible for the consequences of the loan, could there be any logical basis for limiting the recoverable damages. So, my lord, I don't accept what Mr. Savincare said about this. He's saying that you can't get there by legal causation as well, as ordinarily understood. Then on page 1270, paragraphs 37 to 8, Lord Sumption expressly addresses the criticism that the Sanko principle should be treated as an aspect of causation. And at paragraph 38, he does very clearly say that the scope of duty principle is not directed to the question with which legal causation is normally concerned, because at 38, I think probably if this point is important, then it's probably important to read the whole of 38. I'm not going to read it all out, but at letter G, he says it's clear that Lord Hoffman regarded the point as a mere question of terminology, not going to the real root of the principle being applied. The scope of the duty remain his view a critical factor in determining the extent of liability. I agree with this. Questions of causation are normally concerned with identifying the consequences which flow from the breach. If the Samco principle is to be classified as a principle of causation, it is certainly not directed to that question, as the House of Lords printed out in NICredit. The question which it poses is rather whether the risk of loss flowed from the right thing, i.e. from the particular feature of the defendant's conduct which made it wrongful. That turns on an analysis of what did make it wrongful. Whether one describes the principle in Samco and NICredit as turning on the scope of duty or the extent of the liability for breach, it does not alter the way in which the principle applies. So my submission, he is there absolutely clearly saying that it is something beyond the full legal concept of causation. My lords, the point at paragraph 35 is then elaborated on at page 1271, paragraph 41. So that's the point about no legal responsibility for the decision. He is elaborated on at 41 that the responsibility does not extend to the decision itself. ANACO is explained on the next page at paragraphs 43 to 44, where it's held not to stand for any proposition of law. That you see that at page 1273, letter D. It was agreed that the parties agreed that Lord Millett's summary of the law was correct. And then at paragraph 45, Lord Sumption says, as for the Samco cap or restriction, which excludes loss which would still have been suffered if the erroneous information had been true, that is simply a tool for giving effect to the distinction between 1, loss flowing from the fact that as a result of the defendant's negligence, the information was wrong, and 2, loss flowing from a decision to enter the transaction at all. Now, my lords, my lady, that has been correctly understood by the Court of Appeal in this case. as an explanation of the role or purpose of applying the Samco counterfactual. And it has been misunderstood by the Court of Appeal in Asset Co, and in my submission misstated by the appellants before this court, as some kind of license to disapply the principle if the tribunal in question does not approve of the result of doing so. And the obvious difficulty with that approach is that no criterion has been suggested by which it can be decided whether it applies or not. The only criterion appears to be, well, we don't like the answer, so that can't be a proper case. But when one reads this in context, and obviously I don't have time to read it all out, but when one reads this in context, including in particular the remainder of paragraph 45 and paragraph 46, it's completely clear that what Lord Sumption is saying is that it's the tool which we use to achieve that result, and not saying that it's one tool in the toolbox which a court may choose to apply effectively as a matter of discretion. That's absolutely not what he's saying. And in particular, in those passages, paragraphs 45 and 46, Lord Sumption points out that in the Samco case itself, the bank did receive damages that included loss flowing from a fall in the market. So in that sense, the Samco counterfactual approach was more favourable to the claimant in the Samco facts than the approach of trying to separate out loss arising from different risks arising on the relevant transaction. And that's why he says at the end of paragraph 46 that the Samco restriction may be mathematically imprecise as a tool for relating the recoverable damages to the scope of duty. But the effect of what he's saying, and he then quotes Lord Hobhouse, it's a legal rule applied in a robust way, is that imprecision, the award of excessive damages, if you like, in Samco, is the price to be paid for having a workable principle. That's the sense of these paragraphs. So the point that is being made here by the unanimous Supreme Court is that the Samco counterfactual approach, sorry, my Lord Burrows.
If, as I understand your submission, you are saying that this is a principle for which there are no exceptions, we're going to have, are we not, a very clear statement as to when it applies. Now, you pointed, I think, to paragraph 1 of this judgment as if it provided a statement as to when it's going to apply. But the trouble I have with that opening sentence is that it appears circular to me, because you're giving the answer that part or all of the loss which he suffered by doing so arose from which it was no part of the advisor's duty to protect his client against. You've built in part of the answer you're trying to get to. I can't see that can give us a definition as to when the Samco cap is going to apply.
My Lord, if one asks what's the opposite of that part 2, that part or all of the loss arose from risks which it was no part of the advisor's duty to protect against, the answer is the opposite, is that the advisor had a duty to advise on all the risks. And that's the advice situation. So when the advisor is advising the client whether or not to enter the transaction, and the advisor then has a duty to consider all the risks and to consider what the risks are. And that sometimes happens. And if that's the position, then there is nothing to divide. But if that's not the position, then Lord Sumption is saying that's a situation where you've got a transaction which ex hypothesi has caused loss. The advisor has only advised in relation to one or more aspects, and there are other aspects. So all he's saying that where there are some risks that it was not part of his duty to advise. Now, my Lord, I totally accept my Lord's point that it may be in some cases an important question exactly which risks it was for the advisor to advise on. And one approach would have been to say, well, we're going to work out which risks eventuated and caused a loss and whether those were the risks that were being advised on. But the point that I've just been making about what Lord Sumption says about simply a tool is that the Samco counterfactual has been developed as the law's tool for making that determination. You take the advice which has been proved to have been negligent, assume that it was accurate, and ask whether the same losses, which of those losses would still have been suffered. And the ones that would still have been suffered anyway, they're the ones that were not part of what was being advised on, because they, ex hypothesi, come from other risks. And that's not necessarily always precise, as Lord Sumption points out, but nevertheless, it is a robust way of dividing that wheat from that chaff. The law could have gone down a different route of saying, well, it's up to the judge to try to say which risks have eventuated and whether those are the risks that were advised on. But this case actually illustrates how, in a way, how very difficult that could be. Because
the way you've just formulated it would include all cases of negligent advice that you say the Samco counterfactual has to be applied to. But is that right? I mean, the way in which one has tried to distinguish between specific information and general advice would indicate that the Samco cap does not apply in a situation where someone is generally advising on investment decisions.
Well, that's right, my lord. If someone is, if someone has if the defendant advises the claimant to make a certain investment, and that's the end of it, then there's no question of applying a Samco counterfactual, because in that situation, the defendant is advising on all the risks of the transaction that causes the loss.
So you're immediately excluding certain types of advice?
Yes. The advice cases.
All advice cases
wait a minute, my lord. I'm talking about advice with a big A. I'm accepting the information advice distinction from Samco, which.
Oh, you are. That is a sharp distinction, is it?
Yes, my lord. It's a distinction which has been set out in the authorities that I've just been through. That there are circumstances in which the defendant takes responsibility for all the risks by taking responsibility for advising the claimant whether to enter into the loss-making transaction. That's an advice case. The debate in Anaco was over whether on the facts that did amount to an advice case. So there are borderline cases about that. And I accept there are borderline cases. It's a sharp distinction in the sense that even in a borderline case, the court will decide what the answer is. The court decided in Anaco in one way, and it was a difficult case because the House of Lords was divided on it. Nevertheless, that is the distinction. And if it's on the other side of the line, where the defendant is not taking that responsibility, then it's necessary to ask the question which of the consequences the defendant was taking responsibility for.
Thank you.
My lord, I think I'm on, I was just, so on page 1274, I wanted to point out that another piece of evidence, if you like, that what Lord Sumption is really saying is that the principle does apply, rather than that it's a optional tool, is that paragraphs, paragraph 47, he makes the point that it's subsequently been applied by an insurance broker and by the Court of Appeal to negligent legal advice. And then going on to 1276, paragraphs 51 and 52, the claimant had drawn attention to decisions of lower courts in Steggles, Palmer and Portman Building Society, where the counterfactual approach had not been applied. And Lord Sumption's response to that is not to say, well, it was an interesting question and they may have decided it didn't apply, but instead just to say they'd failed to do it properly and those decisions were wrong. And then at 1277, paragraph 53, Lord Sumption expressly considered the question of the burden of proof. Obviously, that's taken on some importance in this appeal, and held that it was on the claimant. And I've pointed out that to some extent that was required by earlier authority, because in both Samco and NICredit, it was already clear that the judges who decided that took the view that the burden of proof was on the claimant. Nevertheless, it's reconsidered by the unanimous Supreme Court in Hughes Holland. And even though in the end they decided that it wasn't necessary to rely on the burden of proof because Lord Sumption analysed the facts for himself in the Supreme Court, nevertheless, the court decided that it was not a straightforward question, and that may reflect some of the points that have been raised in this hearing, But nevertheless, it was a point that the court chose to decide and decide expressly and hold that the legal burden does lie on the claimant as part of proving their loss, or as Lord Hoffman would have put it, proving the loss was within the scope of the duty. So it's the amount of damages which are recoverable, not necessarily the amount of damages that they've suffered, but the amount of damages which are recoverable. And it's an essential part of the claimant's case that he was owed a relevant duty, as indeed Lord Sumption himself puts it, at letter D. So I was doing him a disservice there. The issue in Hughes Holland was hypothetical, just as in our case, what would have happened if something different had happened. And nevertheless, it was clearly stated that the burden was on the claimant. In the last few paragraphs, Lord Sumption then applies the law to the facts, which is a very short matter, as we say it is in our case, and as the Court of Appeal found it to be in our case. My Lords, the submission I then want to make, having been through the cases, is that actually the position on this is settled law. There has been much discussion in the judgments, in academic writings, and it can raise questions that people find it interesting and difficult to analyse. But the principle is now an established part of the common law. Almost 20 years ago in Anaco, Lord Steyne described it as settled principles and established doctrine. My Lord Burrows put it more recently in a book which is in the bundle. The principle has been cemented into English law, and there now appears no prospect of going back, and that from the perspective of an academic writer who was not keen on the principle. Although it's in one sense relatively useful relative to the common law, the principle has now been stated and confirmed after argument by the highest court as many times as some much more venerable principles of our law. Even if we pass over Caparo and Bankhazer-Ullman, which Lord Hoffman understood himself to be building on, the principle has now been stated in Samco, confirmed in NICredit number 2, Platform Homes, Anaco and Hughes Holland. In those 5 cases involving valuers, insurance brokers and solicitors, the principle's been accepted in more or less identical form by no fewer than 17 Lords of Appeal or Justices of the Supreme Court, including my Lord Hodge in the last one. Against that, not one member of the court in those 5 cases has dissented from the principle or sought to recast it in any significantly different way. Despite all the academic issues and all the discussion and the arguments that have been put before the courts, it has been accepted as being in the form that Lord Hoffman stated it. And the issue that engages the principle is, in my submission, the one in the first sentence of the judgment in Hughes Holland. That is the situation that requires the scope of duty principle and no other principle to resolve it. This court in Hughes Holland chose to address head-on the criticisms of the principle. Lord Sumption called it, at paragraph 47, a general principle of the law of damages. He then responded to the submission that it had not been applied in the right way, in the same way, in certain conveyancing cases, by overruling those decisions. On the burden of proof, this court chose to deal expressly with it in Hughes Holland, dealt with it unanimously. I've shown your lordships that the burden of proof was first argued in Samco as being an objection to the principle, that it would create a difficult burden of proof. But nevertheless, every one of those cases at the highest level has decided or assumed that the burden falls on the claimant. As with the principle itself, it is too late sensibly to go back on that now on the basis of an argument raised in the way that this one has, without any proper challenge being made to previous decisions. And nothing in the present case suggests that there's a serious issue with the burden of proof. There's nothing in the present case which really causes a problem. In any event, as some of your lordships put to my learned friend yesterday, if there was a burden in this case to show that the same loss would not have been suffered later, then it was discharged by the evidence that the mark-to-market was the best available estimate of future cash flows in the swap. And it's worth, and I know questions were put to me earlier as well, that the judge didn't agree with that. But it's perhaps worth looking at how Lord Justice Hamblin put it in the Court of Appeal. And having told your lordships that I adopted the Court of Appeal in full, in the usual kind of way, one spends less time actually looking at what they say. It's taken as read. But Lord Hamblin deals with this at, Lord Justice Hamblin deals with this at page 124, paragraph 87. The fact that the swaps extend further into the future is no reason in principle for a different approach. The society submitted and the judge accepted that an inquiry as to whether MBS will be out of the money over the entire lifetime of the swaps will be speculative and inconclusive, depending on many and varied future events. But that does not mean that the MTM value is meaningless or that it can be dismissed as speculation. As with any discounted cash flow analysis of future earnings, events may prove the analysis wrong. But the mark-to-market value nevertheless represents the best available evidence of the fair value of the swap in question, an assessment of value in a sophisticated market which is regarded as sufficiently reliable to require inclusion as an asset or liability on a company's balance sheet in order to comply with IFRS, and that's true. By closing out the swaps, MBS incurred a liability to pay their negative mark-to-market value, but also obtained the equal benefit of removing a liability from the balance sheet. And that is all absolutely true. And my submission, absolutely correct. So really what it then comes to is the defendant saying that the obviously likely future losses on the swaps will be matched by profits on something else. And that must be, on any view, their burden of proof. And so we say that's the burden that they failed to discharge. And I've shown you some of the factual reasons why the judge was not willing to find that was anything more than mere speculation and not even a lost chance of a substantial sort. My lords, let me now try to say something about Lord Burroughs' question to me about the analogy with wasted expenditure. And I think I should qualify this by saying that I have considered this very quickly in response to the question, but I'll have a go. But I accept that the question of the analogy is a difficult issue. The fundamental reason why ordinary wasted expenditure cases are different is because the claimant and the defendant together agree a contract, a price and a consideration on both sides. In the absence of other evidence, the court assumes that the bilateral contract was a fair one. If the defendant wants to argue that the claimant's expenditure would not have been recovered because the contract was bad for the claimant, then the court will presume the opposite unless the defendant can show otherwise. And in case Yam Seng, which has been mentioned already in this hearing and is mentioned in a couple of the documents in the bundle, my Lord Legate cited on this point the statement of Chief Justice Learned Hand in a case that's not in the bundle, Albert and Son against Armstrong Rubber. And I'll read it out because it's not in the bundle. Chief Justice Learned Hand said, "We cannot agree that the promisor's default in performance should under this guise, make him the insurer of the promisee's venture. Yet it does not follow that the breach should not throw upon him the duty of showing that the value of the performance would in fact have been less than the promisee's outlay. It's often very hard to learn what the value of the performance would have been, and it's a common expedient and a just one in such situations to put the peril of the answer upon the party who by his wrong has made the issue relevant to the rights of the other." So in that situation, there's a kind of symmetry. It's an ordinary bilateral contract, and the value of the defendant's performance is in some way symmetrical with, matches the claimant's outlay. The point about the kind of situations that Lord Sumption sets out in paragraph 1 of Hughes Holland is that those cases are quite different because there is no symmetry. In a case, and a case like ours is a classic example of that. The commercial decision to enter into a course of business, of lifetime mortgages and matching swaps is taken for all kinds of reasons and in the expectation of all kinds of profits. Our contribution as advisors about whether it could or could not be accounted for in a particular way is very minor, and there is no symmetry between the fee that we were no doubt paid for that advice and the expenditure and hoped for profits that the claimant hopes for, not as profits directly of the contract with the defendant. It's not going to earn anything from our advice, but as profits from the other contracts that he's going to enter into all over the world, to take, which he wouldn't have done if we'd given the right advice, but they're not profits from our contract. And that's because in that situation, our advice is only one aspect. And that's why it is appropriate, as this court has already decided unanimously, only a very short time ago, there should be a different burden of proof in the Samco counterfactual to the one in a wasted expenditure case. Lord Legate.
Sorry, can you hear me?
I can now, my lord.
Yeah. Where it seemed to me that there may be an analogy is a slightly higher level of abstraction than the point you've been putting, which I accept is not directly in the same on the same lines. But might you not say that in this sort of case, it's always going to be the question that is raised or arises as to whether part of the loss is not attributable to the negligence, but is to be attributed to the eventuation of risks which the claimant undertook. Now, sometimes it's quite easy applying the Samco principle to distinguish those two parts, but in many cases, of which this one may be an instance, it isn't. It's actually very difficult to disentangle which part of the loss is to be attributed to the negligence and which part to risks which the claimant has assumed. And the principle you might apply in that situation is to say, isn't it, that following Judge Learned Hand's approach, that where that situation, the claimant has been put in that situation where this uncertainty arises, it's only fair to put the burden on the defendant who has made it necessary for the claimant who's caused this issue to arise.
Well,
I think paraphrase it exactly, but you see the.
Well, I think one can always, if you go to a very high level of abstraction, you can always reach that policy idea. Well, if there hadn't been a wrong in the first place, then there would be no need for the court to make any assessment, and therefore the court should lean in favour of the claimant in whatever assessment needs to be made, and that may result in a rebuttable presumption. One can always go to that high level of abstraction. But, my lord, my submission is that the Samco principle has developed, and in the area which it's developed, we're not at that very high level of abstraction. And actually, there is no difficulty in principle in how one applies the Samco approach here. The claimants have understood it correctly in their written case, where they quite rightly say that what the Samco principle requires is dividing the loss between the loss that arose from the transactions and the loss that arose because they had to be broken early. That's the way the claimants put their case in their written case, and that is what the Samco principle requires. There's no dispute about that. The only dispute that arises on this case is, well, what is the loss from breaking early as opposed to the loss for the transactions? And it's only then when you get within that we then get this rather abstruse question of the burden of proof about whether a claimant who had to break swaps that had a clear market value based on their future cash flows can say, well, you defendant, you can't prove that I ever really would have had to pay those cash flows. The 32 million might have been 33 million, might have been 31 million, might have been a bigger difference. And so that allows me to claim from you the whole of the 32 million, as if that was really caused by having to break them early, when in fact it was caused by taking a losing position on interest rates. And my submission, my lord, is that, of course, one can go to a high level of abstraction and say, well, the wrongdoer should pay, essentially. One way or another, the wrongdoer has to pay. But in a case like this, you can see the wrongdoer pays. The wrongdoer is paying an amount which is many, many multiples of any fee it received for this advice already under the judgment that we accept. Why is it the right principle that a negligent wrongdoer should have to pay all the commercial consequences of a course of commercial action that was taken by a claimant for perfectly legitimate business reasons in the expectation of making a large profit on it? As it happened, the profit didn't turn up, but that wasn't the defendant's fault.
Well, if you put it like that, then that's simply stating the Samco principle, and I agree that the defendant should be discharged. But the question is the area of uncertainty, and it seems to me to put a very heavy burden on a claimant if, in order to recover any damages at all, is not only to show that he suffered factually a loss as a result of the defendant's negligence, overcome all the normal causation filters, take a discount, be prepared to take a discount for contributory negligence, but he still then, on your case, loses because he can't prove that had the transaction gone forward, it wouldn't have failed anyway. But it may be also the defendant can't prove that it would have succeeded. So it's the claimant on your approach who ends up losing his claim altogether there, which seems to me not obviously a just result.
Well, my lord, one can have that debate as a question of what's just, and I've made my submission that I don't agree with it. But of course, the claimant in this case is not challenging the fundamental reasoning in Hughes Holland. We know that orally, in contrast to their written application, they've said that they do want to challenge, if necessary, the one little point on the burden of proof. But the whole burden of the decision in Hughes Holland, which isn't about the burden of proof, is exactly that the court has to investigate what would have happened, and the question of burden of proof then is then a question that depends on what one is looking at. And I've shown you the paragraph from Lord Justice Hamblin, and I submit that that is the right way of looking at it. In this case, there isn't a real problem of burden of proof, because even if it was on us, it was discharged in this case by the facts of this case that I've mentioned. But actually, the burden of proof is on the claimant. That's been decided by this court, and there is no good reason to go back on it. There's no suggestion of some new argument in this case that's not been put before. In the end, it amounts to...
Mr. Salcedo, can I just interrupt you?
Yes.
Mr. Salcedo, I don't think it's just me. I think you are breaking up. I don't know if others have had having the same experience.
I see some shaking heads.
Well, maybe
that may be your connection.
I think it may.
Well, I'm afraid it may just be me. I wasn't able to catch what you said during the last 30 seconds or so.
I'll look around the room and I'll ask someone to tell me whether it's on the transcript. Is somebody watching the transcript in the room with me?
Fine.
Yes, it is on the transcript. I think the transcribers have it, but my lord, I fear I may have been repeating points I'd made earlier. I see Lord Leggett smiling at that, so so your lordship may not have missed too much, but it's on the transcript. I'll try and move on. Although these are important points, of course, but I'll try and move on slightly to is audit different? Miss Savinclair disavowed any suggestion that she was making a case that audit was so different that the scope of duty principle generally didn't apply. Instead, she argued it gave rise to problem cases that showed that the approach couldn't always be applied in practice. We disagree with that, but it doesn't matter to this case, and it should be decided in a case where it does arise. This case is not about general audit negligence. As I've pointed out, it is not about the company through its directors or shareholders being misled as to the profitability of its activities, which is the normal case. It's not about a failure to spot a fraud, which is another case that can raise some difficulties about precisely how reliance takes place, and then about how the scope of duty principle might apply. Instead, this is about a wrong piece of advice about an accounting treatment. You can see it summarised, for example, at paragraph 27 of Mr. Justice Tier's judgment. You can also see that this case was correctly distinguished by the Court of Appeal and Asset Co. on this point. It's at page 1037 of our bundle at paragraph 100. We don't need to go to it, but the point they made was that the advice in this case could have been given by another firm of accountants who were not the auditors. Is my Lord the President having difficulty hearing at the moment? Unfortunately, he has to be unmuted, I think, by somebody else.
Yes, I'm afraid, Mr. Salcedo, I can't really make out what you're saying. I'm just getting in touch with the IT engineer to see if anything can be done to improve my reception.
Shall I pause, my lord?
Thank you. It's being suggested to me that that it'd be best if we were to adjourn for a few minutes. How much longer do you think you need, Mr. Salcedo?
Well, my lord, I need to finish by 3:30, which is the time I started yesterday. I don't know if I might be, I mean, whether I've got any time in hand, I'm not sure, not much, but I will cut my cloth as I need to, my lord.
Yeah, well, I'm afraid we'll have to adjourn because I really can't make out what is being said. So we'll adjourn for just a few minutes and resume as soon as we can.
My lord.
I think we can resume now.
Thank you, my lord. I was making the point that this case does not raise any difficult issues about general audit negligence and the scope of duty. This case is about a single piece of accounting advice summarised by Mr. Justice Tier at paragraph 27. And the Court of Appeal in Asset Co got it right when they said at paragraph 100 of their judgment at page 1037 of our bundle that in this case, the advice could have been given by some other accountant, didn't have to be the auditor at all. So it's a very different case to those that might raise difficulties. The example which has been most discussed as raising a difficult counterexample, supposedly for scope of duty, is the dividend one. Your lordships and your ladyship may think that the question whether a dividend falls within an auditor's scope of duty is one that might be best decided in a case where it arises. Nevertheless, it is put forward as showing that the scope of duty principle just doesn't work and can't be applied in all cases, so I deal with it on that basis. As my learned friend showed your lordships, on behalf of another client, I argued before Mr. Justice Fancourt that the proper application of the Samco principle would exclude the dividend in that case from the scope of duty. And as she also showed your lordships and your ladyship, Mr. Justice Fancourt was not convinced. And in particular, she referred to paragraph 117 in Mr. Justice Fancourt's judgment, which is in our bundle at page 1863. And as my lords, my lady know from our written case, in our case, if we have to have a view on dividends in a case where they don't arise, but we rely on Mr. Justice Fancourt paragraph 117 as being correct. And in that context, it's important to recall the point which the point that the cap, so-called, is not the loss and not part of the loss, because the two measures are not components or elements of each other, as Lord Millett said in Platform Homes and Lord Sumption said in Hughes Holland. The Samco principle compares the position of the claimant in the real world with his position in the counterfactual world. And as Mr. Justice Fancourt rightly pointed out on page 1863, in the counterfactual world, the company would have had more assets after paying the dividend than it had in the actual world. That is an orthodox application of the counterfactual approach in line with the way it was applied in the valuer cases. And that brings the dividend within the scope of the auditor's duty to the extent that the auditor's negligence resulted in an overstatement of net assets. And in my submission, that is orthodox, and it produces a just result in which the auditor is liable, but not infinitely liable to the extent that its breach of duty was relevant to the decision to pay the dividend. It's a good example of a case where you can say it's a robust tool, which may not be mathematically precise, because it does not involve investigating precisely what was in the minds of the directors in proposing and the shareholders in approving a dividend at a particular level. It doesn't involve doing that, but nevertheless, it's a robust tool that works perfectly well in a dividend example. My learned friend relied on AssetCo at page 1038 of our bundle, where the Court of Appeal said that the Samco principle was simply a tool that can be discarded if it doesn't reach the right answer. And AssetCo, like ours, was a case where dividends were not an issue. But the Court of Appeal went wrong. So at page 1038, paragraph 102, which my learned friend showed you, the Court of Appeal went wrong by giving too much credence to the argument that I had run that dividends were not recoverable under the scope of duty principle, and took that to the extreme of therefore discarding the scope of duty principle, but not replacing it with any other basis on which a tribunal could determine which risks were within and which without the scope of duty. So my submission is that's totally unsatisfactory, and actually there's a perfectly good answer anyway. The example from Lord Burroughs's book at page 1335 is really subject to a similar answer. So in his example, the lawyer negligently advises that developing a particular product would infringe a third party's intellectual property rights, in reliance on which the claimant refrains from doing so. If it had been true, then he would not have developed it, and so is in no worse position, is the counterexample. But in that case, in the actual world, the claimant has lost an opportunity to profit. And that's a loss recognised by law if it's caused by the wrong. And it is routinely described in the law as being the loss of a chance. In the Samco counterfactual world, the claimant has lost nothing because the chance did not exist or had no value, or even perhaps had a lower value, depending precisely on what advice was given. So the claimant is in a different position in the two worlds, as long as one recognises that what you're talking about is the overall position, as with the lenders, and that the two measures do not have to be measures of, if you like, sort of taken from the same jug. The scope of duty, in that case, covers the basic loss in its entirety. And the answer is exactly the same in the tax example, but it's the same as that, so I won't waste time on it. My lords, my lady, my next topic is legal causation, and my cross appeal if I need it. On the law, as I've submitted, if the court accepts my learned friend's invitation to relabel the law of scope of duty as being an aspect of legal causation, then you will be changing the meaning of legal causation. And if you do that, then I submit we must reach the same answer through the newly expanded concept of causation. Assuming you do not take that step, then we're dealing with the ordinary concept of legal causation. And in that concept, the claimant has the burden of proving both factual and legal causation. And I think a point my Lord Burroughs raised yesterday was what happens to that burden in all circumstances. And of course, if the defendant alleges that an otherwise solid chain of legal causation is interrupted by an intervening cause, then certainly for today's purposes, I'm willing to accept that the defendant would normally bear the evidential burden of establishing that supervening cause. And I know my Lord referred to the lack of authorities on that point. There is a review of the recent authorities on it in the first instance AssetCo decision, which we have in the bundle at 1622. My Lords, I'm not planning to sort of spend time on it, but we do have that in the bundle there. If one could identify separate heads of loss that arise at the end of separate chains of causation, then it will be possible to divide them from each other using the tool of legal causation. But where the chain of causation from breach leads to a transaction or several transactions, which the claimant entered for numerous reasons, the legal causation approach breaks down. And that's when scope of duty is needed to do justice. And in fact, we submit that the judge was in any event wrong on the basis of his findings of primary fact to find that the legal causation test was satisfied in this case. And I turn to that now. Mr. Justice Tier held, and this is page 169, paragraph 149, that there were three effective causes of the society's loss. So he's talking, this is the effective cause, I think, of the basic loss. And what he holds at paragraph 149 is that the effective causes were: 1, the decision to buy the swaps; 2, the subsequent fall in interest rates; and 3, Grant Thornton's negligence. My lords, in making that finding, the judge omitted completely the overhedging, even though that was actually the main cause of the loss. It was common ground at trial that it was the main cause of the loss, save that during the claimant's oral reply submissions on the last day, my learned friend resiled from it, and we say the judge was completely wrong to allow her to do so in circumstances where we had no opportunity to call expert evidence or examine the disclosure on the question of what was the main, of how much that contributed. We've maintained that point at every level of appeal. It was very clearly common ground. I think you see in the judgment the reference to the claimant's opening skeleton. It was also referred to in the oral opening submissions of both sides that point was common ground. So I maintain that point, my lords. I know it's not the kind of point the Supreme Court normally deals with, but technically speaking, it remains a point that I have to take because it remains in play. But anyway, even on his finding that I showed you earlier today at page 193, paragraph 253, that overhedging led to significantly more than 22% of the net loss, even on that finding, it is absurd not to recognise it as an effective cause of loss. And it implies that the judge, in making his assessment of effective cause, has erred in principle and not fully understood the principle or not fully applied it in the right way. There's no way in which a contribution of more than 22% cannot be one of at least what would then be 4 effective causes. So that gives you, that would give you, in the judge's view, 4 causes: decision to purchase the swaps, the fall in interest rates, the overhedging, and Grant Thornton's negligence. And in my submission, when you look at those 4 on the facts of this case, and you look at them against the very well-known dictum of Mr. Justice Devlin in Heskell and Continental Express that we've cited in our written case, it's in the bundle at page 2002, but there's nothing in the context. It's just the dictum that legal causation identifies effective causes, but multiple causes when they are of approximately equal efficacy. When one applies it against that, it's actually blindingly obvious that between going into this business at all, the disastrous fall of interest rates in the financial crisis, and the decision to take a punt on interest rates by overhedging, which was the main cause of loss, against that, Grant Thornton's negligence that meant that this business had to be broken rather than carried through to the bitter end, and it would have been a bitter end, is a really minor cause and should not have been classed as an effective cause alongside the others. So, my lords, we say that if we don't get home on scope of duty, we actually get home on a proper understanding of legal causation. The Court of Appeal, because they upheld our position on scope of duty, didn't deal with this. But my lords, it has always been a point that we pursue. My lords, I seem to have actually done better than I expected. I'll look around the room to see if no one is telling me I should say something else. And it may be that I don't know if any of your lordships or my lady have questions that have not yet been raised. Lord Burrows.
Forgive me, I can't quite remember, but was there any reference by Mr. Justice Tier to the overhedging in his discussion of the contributory negligence element?
Yes, my lord. That is at paragraphs near the end of the contributory negligence. It's paragraph 239 on page 189 and 190 of the bundle. I think I showed you this morning, mostly at the top of page 190, that Mr. Justice Tier found that it was indeed negligent of the society to overhedge because their reason for doing so was taking a view on long-term interest rates.
Yeah. Thank you very much.
Well, thank you very much, Mr. Salzido. I think we can then turn to Ms. Sabanclair for a reply.
Thank you, my lord. I hope that everyone can hear me. Good. My lords, my lady, can I start please by taking you back to Mr. Justice Tear's judgment at page 136 of the bundle. We're here at the start of the judgment, and Mr. Justice Tear was recounting the events which had led to the claim being made. And he records in paragraph 18 that the claimant's financial position properly reported was wholly different from that which had been previously stated in its audited accounts. The profit for 2011 of 6.35 million became a loss of 11.44 million. Net assets reduced. The regulatory capital position was very different. It was now a deficit of 17.9 million. And he records there the point that I made yesterday about the twofold effect of hedge accounting. That's being required to hold more capital and having less of it. As to having to have more capital, that's addressed in his final two lines. The claimant was required to hold more capital because of the risk of volatility to which it was now exposed. As he says in the next paragraph, the claimant was forced to close out the swaps. It reduced its new lending and in fact stopped lending on the 5th of December 2013. Its book of UK lifetime mortgages was sold. The book of Spanish lifetime mortgages hasn't been sold despite efforts to do so. What the judge was there recounting was that the discovery that the society could not apply hedge accounting had led to the collapse of its business. The society did not seek to recover all losses from Grant Thornton that would not have been suffered but for the negligence. For example, there is no claim in respect of the fact that the society has been unable to make any new lending since 2013. It has effectively been in runoff. But there is a claim in respect of losses suffered by reason of the termination of this particular business model, the lifetime mortgage model hedged by swaps, which were caused in 2013 when the society had to close its position out of that business. That was why there were claims for closing out the swaps and for the loss of opportunity to continue to hold a UK mortgage book. Also the claim for restructuring costs. You'll see those last two claims at paragraphs 214 and 223 of the judgment. So the question raised by the case was whether losses incurred in 2013 were ones that the law regards as solely attributable to the commercial decision-making by the society, or whether it regards them as attributable to both the society and Grant Thornton. I put it in that way, either just the society or both, because we always recognised that there would be a deduction for contributory negligence. It was always our case that the law regards it as sufficient for the contract breaker or tortfeasor to be an effective cause of the loss. It doesn't have to be the sole cause of the loss. And therefore, it was our submission, and it remains our case, that the losses are ones for which responsibility is properly allocated to Grant Thornton, but that will then be tempered by the application of a sizable deduction for contributory negligence. Now, up to the point of his decision on scope of duty, the trial judge who'd heard the evidence agreed with our analysis that legal responsibility for the losses which he had found to be proved on the facts lay with both parties. The question then raised by this appeal is whether, having concluded that Grant Thornton was an effective cause of reasonably foreseeable loss, which would not have been suffered but for the breach, the judge and the Court of Appeal were right to regard scope of duty as another and separate filter, the application of which meant that Grant Thornton was not, after all, to be regarded as legally responsible for the swap loss. And I now say swap loss because the swaps were much the biggest head of loss, and therefore they're the head of loss that has been appealed. You will have seen footnote 63 to the respondent's case, where Mr. Salcedo says that if we win on this appeal, he will want credit for some mortgage gains. The question whether scope of duty is an additional filter, which meant that notwithstanding we'd won on the other points, we should lose at this stage, is one that arises whether scope of duty is put first or second, though that is a point I'll come back to. In our submission, the judge and the Court of Appeal were wrong in their conclusion on scope of duty, and the right outcome is the 50% allocation to each party that otherwise stands. And I want briefly to recap the reasons why we say that. Our first point is that BPE paragraph 38 identifies the question on scope of duty as being, did the right thing cause the loss? Similarly, Samco at page 214, letter B, explains that the moral of the mountaineer parable is that it appears to make the doctor responsible for consequences which do not have sufficient causal connection with the subject matter of the duty. Sufficient causal connection is a test of legal causation. That has been applied most recently in the Supreme Court in the Thornton shipping case to the flip side of the coin, when considering the legal filters that apply to gains that would not have been accrued but for the wrongdoing. Now, just pausing here, and so my first point is that the test is sufficient causal connection. Mr. Salcedo countered that by taking you to references in BPE and Samco, which say that this is not a principle of but-for causation. But in my submission, each time those words are used, they are qualified in a way that make it clear that the judges there were meaning to distinguish factual causation, in the sense of but-for causation, and legal causation. Every time the point is stated, it's not causation, there is some form of qualification in the words used. And the distinction being drawn is particularly clear from paragraph 58 of Lord Millett's speech in Anaco, which says that it's necessary to separate causation, which is a question of fact, and the issue of legal responsibility. And obviously that is a question of legal causation. Mr. Salcedo submitted that Samco is a principle of settled law, but of course that begs the question what the Samco principle actually is. With the exception of my contingent challenge to paragraph 53 of BPE, I have built my case before this court firmly on what is actually said in those cases. I'm not asking you to put a line through those cases, rather I'm asking you to explain what is said in them. So what is the principle? You have our submission, it's did the right thing cause the loss? But as formulated by Mr. Salcedo today, the principle is a special rule of law applying to claims for breach of contract against a professional advisor who is a cause but not the sole cause of their client entering into a particular transaction. He says that's a rule that may not be deviated from in any circumstances. No exceptions, he says to you. But in our submission, that only has to be stated to be seen to be wrong. It would be an extraordinary thing to have a special principle of law in one area of contract law only. And it is entirely contrary to the judgment in Samco, which makes it clear that Lord Hoffman thought that he was explaining existing rules, not creating a new one. But what Mr. Salcedo's answer does reveal is that, of course, Lord Hoffman was dealing with the particular situation arising on the cases before him, a rash of valuers' negligence cases and the facts of those cases. So I've spent some time on my first point about what the principle is. My second point is that in light of the underlying principle in Samco, it was incoherent to reach a conclusion that Grant Thornton was the effective cause of the loss at the stage of legal causation, and yet to hold that it was not responsible at all under scope of duty. My third point is that the right answer to this appeal is not that therefore the judge must have got it wrong on effective causation. On the contrary, and my lords, if I can ask you please to turn back to page 168 of the bundle and paragraph 146. The reasons for reaching his conclusion that the judge gave here were very good ones for concluding that Grant Thornton was at least an effective cause of the loss, from which it follows that responsibility should be attributed to them. He says that to say that they merely provided the opportunity for the claimant to suffer the loss seriously underplayed the causative potency of the defendant's negligence. And he comes back here to the beginning of the story that the use of hedge accounting was intended as recognised by the defendant in November 2005 to mitigate the effects of volatility in the fair value of the swaps. And then he goes on to explain that the swaps had to be closed out once it was appreciated that hedge accounting could not be applied because of the volatility risk to which they arose. Now, I just want to make 3 points here in response to arguments that have been raised or questions raised by the court. The first is that Mr. Salcido was right to explain to the President that the bulk of the swaps were purchased after the advice had been given. You can see that from paragraphs 9 and 10 of the judgment, which tell you that there were 14 UK swaps and 14 euro swaps against the Spanish book. They're also listed in paragraphs 81 and 94 of the judgment. And as the judgment also says, only 3 had been taken out prior to April 2006. The second is that the society could not have continued to hold the swaps and wait for the market to improve once the position was realised in 2013. That was the point addressed by Mr. Harding in his evidence set out in paragraph 142 of the judgment. The problem wasn't the swaps being out of the money per se. The problem was the volatility. So the claimant couldn't continue to hold the swaps. The third is that Mr. Salcido's principal attack on the judgment on this point, as presented to you today, was to say that the judge had failed to take into account the over-hedging as a cause of the loss. But in my submission, that point is plainly wrong. First, paragraph 149 refers to the decision to purchase the swaps. And that, in our submission, plainly encompasses the duration of the swaps and therefore the over-hedging point. Second, as Lord Burrows rightly said, this point was addressed in the section on contributory negligence, and it was addressed there under the heading causative potency. Now, in light of that, when one looks at the judgment alone, it is clear that the judge had well in mind the causative effect of the over-hedging. Moreover, as will have been apparent to you from the presentation of this appeal, the judge had heard a great deal about Mr. Cowie's memorandum over-hedging the commercial decision to enter into the swaps of this particular duration. And the idea that the judge simply overlooked this point when addressing causation is, in our submission, fanciful. I move on to my fourth point. We say that the judge did not need the Samco information analysis in this case because the answer to the question, did the right thing cause the loss, is to be collected from all the circumstances of the case, the Samco advice and information dichotomy, providing a tool to assist in analysis, not a black letter rule of law. That analysis was singularly inapposite to the facts of this case. because the case of breach against Grant Thornton arose from its auditing over many years, as well as a lone piece of advice, and it didn't relate to any particular transaction, and it gave rise to a speculative question that was literally incapable of answer. Our fifth point, if we're wrong on all of that, so we're wrong in saying that the Samco information analysis didn't arise, we say then that all that was required was proof that MBS would not have suffered the same loss at the same time if the information had been correct. Can I take you back here, please, again to the first instance judgment, page 179, paragraph 192. The judge there recorded exactly the submission that I've just repeated before you, that it was sufficient for the claimant to show that had the defendant's advice been correct, the claimants would not have closed the swaps in 2013 and so would not have been obliged to pay the cost of closing the swaps. Then at paragraph 193, the judge accepted that submission. He referred to Samco as a tool, but in any event, he then continued in the last 4 lines, I would not have reached the same decision by reference to this particular tool. On the facts of the present case, the losses would not have been incurred had the information or advice been correct. The claimant would not have incurred the cost of closing out the swaps because the swaps would not have been closed out. We submit that he was exactly right there. My sixth point, Samco does not require a claimant to prove the negative that it would not have suffered some other loss at some other time in an equivalent amount. And by saying that it did in paragraph 88 of its judgment, the Court of Appeal there went beyond Mr. Justice Tier. That's not required because any such rule would impose an impossible burden on a claimant in a case such as this, where the defendant's negligence has put an end to a project intended to stretch years in the future. It would bring into the arena matters usually regarded as legally irrelevant. And I pause here to say that that is a submission which was made good by Mr. Salcedo's reference to the FCA material and the business plan. For example, he showed you there was talk of a possible merger. Well, the consequences of a merger aren't something that ordinarily would be regarded as a consequence of Grant Thornton's negligence, but they necessarily are part of the question what would have happened in the future. Coming back to my script, the idea that the claimant has to prove the negative is also contrary to the rule that it's for the defendant to prove that the claimant has entered into a bad bargain, which is what the plea amounts to. The uncertainty was created by the breach of contract, and if this is a relevant issue at all, which we say it isn't, the burden must lie with the defendant. Now, a number of questions have been asked today about whether scope of duty comes first or second. We adopt what was said by Lord Justice Jackson at paragraphs 74 to 77 of the Grange decision, which is actually a case that was mentioned in our application for permission to appeal. But in any event, we submit that the answer to what comes first also appears from Samco and BPE themselves. And I do just want to show you, please, the 2 passages in those cases that I rely on there. First, if we can go to page 1314, please. So Mr. Salcedo showed you that Lord Hoffman starts by saying that you can't start with a measure of damages, but then he says this at page 216, at letter D. He says that the measure of damages in an action for breach of a duty to take care to provide accurate information must be distinguished from the warranty damages. I'm not reading out verbatim there, but summarising. So he makes the point that the measure of damages in a breach of duty of care case is, and I'm now 4 lines below letter D, In a case of a breach of a duty of care, the measure of damages is the loss attributable to the inaccuracy of the information which the plaintiff has suffered by reason of having entered into the transaction on the assumption that the information was correct. One therefore compares the loss he has actually suffered with what his position would have been in if he had not entered into the transaction, but for, and asks what element of this loss is attributable to the inaccuracy of the information. So Lord Hoffmann was there himself, notwithstanding his starting point, recognising that in a contractual case, because of the measure of damages, you do have to start by identifying the measure properly recoverable in contract, and then you ask for what part of that does the defendant have legal responsibility. And that is, of course, exactly the approach that was then followed in NICredit, of starting with the basic loss and then saying how much of this can be allowed. As for BPE, can we go to 1268, please? This is Lord Sumption at paragraph 32, where he addresses the Samco cap. And of course, he's conscious here of the criticisms that have been made of that. And he says at letter E that Lord Hoffmann himself rejected that label. And he refers to the two stages, 4 lines down. The first involved ascertaining what loss the claimant would have avoided if the defendant had performed his task carefully as he should have done, whereas the second involved awarding only that part of the loss which was within the scope of the defendant's duty. So Lord Sumption's explanation of what was happening in Samco is exactly the same in its analysis of the first stage and the second stage of the argument. Now, what I've done so far is to set out my case in outline, and I want now to pick up some particular points that have arisen during the course of the last 2 days. The first of those points is the question, was there a loss, and if so, what was it? I was pressed yesterday on the question whether there really was a loss, and Mr. Salcido opened his submissions by saying that there's no loss in paying the MTM value of a swap you already hold, because it exchanges an existing liability, his words, for money's worth at fair value. He described it as an existing liability, a real liability. That's page 124 of yesterday's transcript. And he went on to say that the MTM was suffered whether or not the swaps were broken, page 126. Those submissions, my lords, my lady, are wrong because there was no existing liability to pay the MTM. That is the point of the arrows diagram. The existing liability was to pay the 6 monthly payments, not to pay the MTM. That is the point that I rely on the diagram for. There was a debate between the forensic accountancy experts at trial as to the outcome of the arrows diagram in each year preceding 2013. Mr. Salcido rightly and fairly took you to some passages of cross-examination in which he made progress, and reasonably so, with my expert on the question whether there was a fixed locked-in margin. But what he didn't do was to show you what his own expert evidence was. And I just want to take you, please, now to page 793.
Just before we do.
Yes.
I seem to be echoing. Do you accept that we've seen from the internal documents of the Building Society that one of the concerns was that the counterparties to these contracts could themselves have terminated them and compelled the Building Society to pay the the capitalised value of their liabilities.
Yes. There was quite a lot of discussion about this at trial, my lord. It was addressed by the expert evidence. And that situation had actually happened in 2011 when one of the swap counterparties had decided that it wanted to exit that particular type of swaps. But it didn't cause a loss, my lord, because if you're released from one swap obligation but want to take on an equivalent one, you will buy in at equivalently good value, effectively. So there wasn't, in fact, a loss then, because they were swapping one thing for another, too many different kinds of swaps. But, my lord, there was evidence about this at trial. It's not in the materials before you. You're right to say that there was a concern about the swaps being broken. But that is not something that goes to the question whether the MTM had in some way been incurred already. That's rather to postulate at most, and so even if it was a loss, is to postulate that something else might have come along to cause the same loss. But it hadn't in relation to these swaps as at 2013. So if we can go please to page 793. We're still in the expert report of Mr. Smith, who was Grant Thornton's expert forensic accountant. The preceding page had the arrows diagram, which I've shown you. Then in the table on this page, Mr. Smith made some points about the funding costs to the society. His point there being that the funding costs were more variable than my expert had suggested. And at paragraph 13.14, he concludes in the last 3 lines, however, if I adopt the average funding spread from 2009 to 2013 that I have identified, and deduct this from Mr. Hall's calculation of the locked-in margin, the effect is to reduce the margin from 1.64% to 0.8%. So, my lords, I'm not suggesting that you're going to make a finding about what the margin actually was, but my submission is that there is no basis for some sort of assumption that this was a bad bargain, which seemed to be a route that Mr. Salcedo was going down. But most importantly, it simply isn't right to say that it had been proved that the same loss would have been suffered in any event. Such evidence as there was of the outcome of the arrows diagram, the hedging model, as was before the court, involved a marginal debate about margins and nothing like the losses actually incurred in 2013. What those figures also show you is that there is no loss simply through a swap being out of the money. After the financial crash, these swaps were out of the money. But it didn't matter because for so long as the society held the swaps, any adverse movement on the amount paid under the swap was cancelled out by the gain in paying less by way of LIBOR to the society's savers. Two floating limbs cancelling each other out. The next point I wanted to cover was the Samco counterfactual. What is the world in which Grant Thornton's advice is true? Can we go here, please, to page 929 of the bundle? This is IAS 39. This is the applicable standard. I didn't take you to this yesterday. I perhaps should have done. In the bold text in paragraph 88, you'll see that the accounting standard says that a hedge relationship qualifies for the hedge accounting if and only if all of the following conditions are met. And B is that the hedge is expected to be highly effective in achieving offsetting changes in fair value or cash flows attributable to the hedged rest. And E says that the hedge is assessed on an ongoing basis and determined actually to have been highly effective through the financial reporting. So the standard was historic effectiveness plus prospective effectiveness, that's B and E, and that required reassessment on an ongoing basis, that's E. So we do say that in a hypothetical world in which Grant Thornton's advice was correct, there would have been an effective hedging relationship within the meaning of this standard. What does that mean? It means that the information in the schedules with the duration of the mortgages would have been correct. No losses, because the income flows, the arrows would cancel each other out. Furthermore, as Mr. Salcedo accepts, Grant Thornton's advice assumed that there would be substitution. It's irrelevant that Grant Thornton did not advise whether substitute mortgages would have been available or not. What we're concerned with is a world in which its advice was correct. There would, in that case, have been an effective hedge relationship, so there would have been substitution. Next point is Mr. Lord Leggett.
I just wanted to pick you up. I don't think that last point could be right. There would have been the possibility of substitution, but whether it was actually achievable or not wasn't something that Grant Thornton advised about.
No, I accept that they didn't advise about whether it was actually achievable or not, but they did advise that there was a prospective hedge effectiveness. That necessarily in the hypothetical world, and remember, we're not concerned here with but-for losses. We are concerned with a hypothetical, what would have happened if the advice had been correct. That world is itself a fanciful one, I'm afraid, because the advice was wrong. I mean, that's part of the problem of all of this exercise. It is a fanciful world to imagine that advice is correct when it very obviously wasn't. But the world in which it is correct is one in which there is hedge effectiveness. And perhaps one doesn't need to complicate this with substitution. It's enough for me to say the schedules would have been right. Yeah. Regulatory concerns. Mr. Salcedo's account of the primary facts about the mortgages yesterday included references to the regulator's concern about the lifetime mortgages. And he repeated that again today with his 6 points about the reasons for the value gap. Those points were much pressed at trial. The case that the regulator would have closed down the business, forced the sale of the swaps, failed. And I want to take you again, I'm afraid, to Mr. Justice Tier, paragraph 181, page 178. So the judge here records the submission that even if the advice had been correct, the regulator would have required the claimant to dispose of its lifetime mortgages in a phased way. In those circumstances, it's likely that the swaps would have been broken because they wouldn't have been hedging anything. And so the claimant would have been in materially the same position. That was the defendant's argument, seeking to prove that we would have suffered the same loss anyway. That case failed. If you look at paragraph 185, you will see the judge recording the point that a sale of all or the greater part of the lifetime mortgages would have necessitated the closure of all or the greater part of the swaps. That would cause the claimant to suffer the very type of loss which it and the regulator wished to avoid. It's not likely that the claimant would voluntarily suffer or the regulator would wish to impose such a self-inflicted wound. He then went on to refer to and accept my client's expert evidence about the attitude of a regulator, and he concluded at paragraph 189, had the advice been correct, I consider it's more likely than not that there would have been renewed efforts with the encouragement of the regulator to dispose of some of its lifetime mortgages However, it is more likely than not that such efforts, even if successful, would have stopped short of being so extensive that the claimant was forced into the position of having to close down any of the swaps and thereby incur substantial loss. And he makes the point again that the regulator was seeking to prevent the claimant from suffering loss rather than ensuring that it did. So, my lord, all of the points made by Mr. Salcedo were ones that had been considered by the judge and rejected at trial. I would also point out that Mr. Salcedo's submissions focused on the lifetime mortgages, but as you will appreciate, all that would have been required to offset the swaps was any form of fixed rate lending. Didn't have to be lifetime mortgages. Any form of fixed rate lending would offset the fixed rate leg of the swaps. From page 23 of today's draft transcript, Mr. Salcedo made a further and remarkable assertion that as of 2013, it was crystal clear that no such lifetime mortgages would ever have come into existence. There is simply no such finding. Lord Legate was quite right at page 26 of the transcript to put to Mr. Salcedo that if he needs that finding, he doesn't have it. Next, Mr. Cowie's role in the commercial decision to take on 50-year swaps. Relying on the decision to take on long-term swaps is also a repeat argument. I've already explained that that argument featured large before the judge. You can see that from paragraph 147 of the judgment. It failed. This is a contributory negligence point and a contributory negligence point only. Lastly, ASICO, and the question, is this an ordinary audit negligence case, whatever point that may be? Mr. Salcedo made the bold submission to you that if the 2006 accounts had been corrected, it would not have alerted anyone to a problem. That was a remarkable submission, my lords, and it is wrong. We start, please, by going to page 954. These are the notes to the financial statements for 2006. So notes audited by Grant Thornton, passed as giving a fair view, true and fair view of the society's financial position. And this includes, under the heading hedge accounting, that the group uses derivative financial instruments to manage interest rate risk. And it explains that hedge accounting is applied. And it explains in the last sentence of the first paragraph under this heading, this practice therefore considerably reduces the volatility of movements within the income statement and was fully implemented from the 1st of January 2006. Now, if that note had not been there, and if the position was that hedge accounting could not be applied, there would have been volatility, and that would have had to be recognised. If you turn back to Mr. Justice Tier, please, at paragraph 127. He's dealing here with the question, what would have happened in April 2006 but for the negligence? And he says, he says, starting 3 lines down, but given that long-term swaps expose the claimant to the risks of volatility and to consequential higher demands for regulatory capital, it appears to me more likely than not that the claimant would not have taken out any more long-term swaps. He says that the swaps, which he describes, would have been recognised as giving rise to the risks of volatility and to consequential demands for regulatory capital. So Mr. Salcedo is, with respect, quite wrong to say that no one would have been alerted to a problem. had Grant Thornton's advice been correct. The judge has found to the contrary in that paragraph. Lord Sales was, in light of that paragraph, quite right to put to Master Salcedo that hedge accounting was the gateway to this business model. That was exactly what the judge had found. Now, having seen those findings, I'd like to take you back, please, to the way the case was pleaded, page 505 of the bundle. Mr. Salcedo suggested that the case had somehow not been presented as an audit case. But if you look, please, at paragraph 75, what you'll see here is that the culmination of our pleading of all the things that have gone wrong is that the society wouldn't have taken any of the steps set out above, that's taking on the various mortgages and swaps, but for the breaches of duty. And we explain that, I'm going to summarize, this was all about potential volatility. And the last 7 lines or so record, further alternatively, the society was a relatively small building society with a modest capital base, which was underpinned by a combination of permanent interest-bearing shares and subordinated debt. In light of this, the society was unwilling and unable to introduce any element of material risk. We say all of that was known. The impact of hedge accounting on the income statement, capital reserves, volatility and regulatory capital was known to Grant Thornton and obvious. And then we deal in that context with their awareness of the intention to expand the business. So, my lords, the theme running through all of this is volatility. It's the advice on volatility that's recorded in the financial reports in the note. It's advice on volatility, which leads the judge to conclude that the swaps would have been closed out in 2006. And it's advice on volatility, which the judge finds to be the cause of the losses in 2013. And all of that was squarely pleaded by paragraph 75. So the only difference between this and what Mr. Salcedo describes as a normal audit negligence case is that the misstatement bore on the amount of regulatory capital that the society required and not to the payment of a dividend and not to some form of other trading loss. Well, so what? That doesn't make the principles of law that are applicable different. It doesn't make it a somehow unordinary audit negligence case. It's an ordinary audit negligence case because there's a material misstatement. Now, to bring these threads together, I'd like to take you, and it's the last thing I'll ask you to turn up, back to Anico at page 994. In the top left of this page, the continuation of paragraph 16, right at the top of the page, and we're still in the speech era of Lord Stein, the judge says, and I'm 3 lines down, that if they, that's the brokers, had performed that duty carefully, they would have told the insurers that reinsurance was not available, in which case the whole thing would have collapsed, as the brokers well knew. These issues are ultimately ones of the attribution of responsibility. In Anico, the developed judicial instinct of 4 out of 5 judges was that the brokers should be held liable for the whole loss. And I suggest that this is why it was obvious that if the duty had been discharged, the whole thing would have collapsed, as the defendant well knew. And we say standing back and considering the just outcome of this case, this is also a case in which the whole thing would have collapsed without hedge accounting, as Grant Thornton well knew. Grant Thornton should be held legally responsible for their negligence, but the society must be too, and that is why the judge's finding of a 50% application of contributory negligence was right. I end where I started. The reality is that this business collapsed. It came to an end. The society's business came to an end when it discovered that it could not apply hedge accounting. Mr. Salcedo's submissions defy the reality that it was the inability to apply hedge accounting that caused this financial collapse. But unless I can help the court, those are my submissions. Lord Burrows.
This is a very minor point. I think I'm echoing.
I can hear you perfectly well.
Sorry, you have occasionally stressed the contractual element of the claim. I'm assuming that you are not making any point at all about any distinction between the contractual duty of care and the tortious duty of care.
No, I'm not. The reason that I stress the contractual nature is that we do say that in a case where there's an express contract, the recent Caparo indictment type issue about the extent of the duty, because that's defined by the contract. And another way of putting that may be that the concept of scope of duty isn't of itself in a contractual case at all helpful in answering the question, what should the defendant be responsible for? Because the answer to that must be the defendant is responsible for performing his contract, and the extent of his liability is the contractual rules applicable to damages in contract. I may not have put that very well, but the reason that we raise the point is this one, that scope of duty doesn't really answer the question, what should the defendant be held liable for in this context?
Okay, I think I might be understanding you also to be indicating that there is no question of there being a duty of care in this case, whereas in Caparo, the whole question was whether there was a duty of care.
Yes, exactly, yes.
Thank you.
Good. I can't see any more hands.
No, I think you've given us all the assistance that we could hope for, Ms. Savinclair. We're most grateful to you and to Mr. Salcedo and those who've been assisting you for your submissions. We'll now take time to consider our decision. The court will now adjourn.